Hi and welcome back. I'm Chris Prescott. I'm the Senior Immigration Attorney at Patel Law Group. This is the second installment in the H-1B video series. In the first video, we did an introduction to H-1Bs and went over some of the more basic concepts. In this video, I'd like to address some more specific issues and some more related issues, particularly given the current pandemic. Over the last few months, a lot of employees have lost their jobs, they've been furloughed. So the first issue I would like to look at is whether it's possible for a H-1B employer to furlough an employee. On the reverse side, I also want to look at the options for an employee in the unfortunate event that their employment is terminated. So let's get started with the first question. So this question concerns the issue of benching. Benching is essentially where you have someone employed on a H-1B and then all of a sudden there's no work available for that employee and the employer decides to stop paying the employee the prevailing wage. You may recall from the last video we talked about the need to file an LCA, and that by filing the LCA, the employer is attesting to pay the prevailing wage for the duration of the H-1B validity period. So that obligation and responsibility to pay the wage is not dependent on the availability of work. And just to clarify, benching is really the same thing as furloughing. So when an employee is furloughed, they're being asked to take a leave of absence without pay. So to answer the question, can an employer either bench or furlough an employee on H-1B? The answer is no. The reason for this is that the law specifically states that an employer must continue to pay an employee during periods of non-productive status. This issue crops up most frequently with IT staffing firms. You may recall in the last video I mentioned IT staffing firms. The reason I mention them is because they utilize the H-1B program more than any other employer. So with an IT staffing firm, the scenario is that the IT staffing firm is the employer, but the employee is usually working at an end client location, in other words, a third-party location on an end client project. If that project comes to an end suddenly, that employee may find themselves without work. However, whether it's a few days, a few weeks, or a few months, the employer must continue to pay that wage. I mentioned also in the previous video, a failure to pay that wage is a violation of the regulations, and it would also give rise to a wage complaint with the Department of Labor. So if an employer does decide to bench or furlough someone on H-1B, they could be looking at a complaint that's filed with the Department of Labor. What that would mean is that they would have to pay back that missed pay. They may also face penalties which could run into thousands of dollars, and in the worst case scenario, they may be prevented from filing further H-1Bs. So going forward, if an employer doesn't have work available for an employee, the only way to stay compliant with the regulations is to continue to pay their wage. That isn't to say that if a H-1B is approved for 3 years, that they have to continue to employ them for 3 years. They can still terminate the employee, but that would require going through several steps. Those steps we will discuss in the next question. In the event that an employer decides that they can no longer continue to employ a H-1B worker and they want to effect a bona fide termination, there are 3 things which the employer must do. Number 1, they must notify the employee in writing about the termination and tell them their last date of employment. Number 2, they need to notify USCIS and specifically request that the H-1B is withdrawn. Number 3, they have to offer the employee the reasonable cost of return transportation back to their home country. Now, all 3 things need to be done. If only 2 out of the 3 are done, then an employer could continue to be liable for back pay. In the last question, I talked about how an employer could terminate a H-1B worker's employment, but where does that leave the employee? So previously, if an employee was terminated from their H-1B employment, they were immediately out of status. So if they were laid off on a Friday, what that means, or what that meant, was that they would have to leave the US immediately. However, the Department of Homeland Security issued a regulation in November of 2016 which provides for a 60-day grace period for H-1B workers where there is a cessation of employment. This took effect in January of 2017 and essentially provides a 60-day grace period to allow the H-1B worker to find either another employer to file a new petition, to file a change of status to another status such as an F1, a B1 or a B2, or to make preparations to leave the US. So rather than having to leave immediately, they have 60 days in which to try and kind of rectify their status. What this means in practical terms is if you're working for employer A and get laid off, then you have 60 days in which to find another employer, i.e. employer B, to file a new H-1B transfer. As long as that petition is filed within the 60-day grace period, you would continue to maintain H-1B status and you would be allowed to work for the new employer as soon as that petition is filed and received by USCIS. And the same goes for spouses and children in H-4 dependent status. They would continue to maintain their status. If the spouse has an EAD, he or she would be allowed to continue to use that EAD, i.e. work authorization, as long as that petition is filed within the 60 days. Now, the 60-day grace period is discretionary, which means that it's really up to the discretion of the officer whether to apply that 60-day grace period. In my experience, when the petition is filed within the 60 days, that discretion is usually exercised in favour of the applicant. Now, if you're filing outside of the 60 days, my advice would be to leave the US wherever possible, because when you file outside of the 60 days, that case is more than likely to be approved for consular processing only. Obviously, amid COVID-19, travel restrictions, closures of consulates, if it's not possible to leave, then when you file the H-1B transfer, I would recommend not working, but then making a request that the officer again exercise their discretion in favour of you based on the fact that it's impossible for you to leave the US. The one thing to note about the 60-day grace period is that it's either 60 days or whatever is left on your authorised stay, in other words, your I-94. So if you're currently on a H-1B and you get laid off and you've only got 40 days left on your current H-1B, you would only be entitled to a 40-day grace period. You wouldn't get the benefit of the full 60 days. The same would go for someone whose I-94 has expired and they have an H-1B application pending, in other words, an extension. If that application is pending and the I-94 has expired, then unfortunately in those circumstances there would be no grace period. So just to conclude, the 60-day grace period either gives you the option to find another employer, to file a change of status to another status such as F1, B1, B2, or it gives you more time to prepare to leave the US. So whenever someone obtains a H-1B approval, they are only authorised to work for the employer that filed the original petition. We've talked about H-1B transfers and switching jobs. However, what happens if somebody wishes to work for two employers at the same time? Is this possible? The answer is yes. In order to work for an additional employer, that additional employer would need to file what's called a concurrent H-1B filing. And it's worth noting that the majority of concurrent filings are typically done for part-time employment. That's because if you have an employee who is already working 40 hours a week, then if they file a concurrent filing for an additional 40 hours a week, it's possible that USCIS could question whether it's really the employee's intention to work 80 hours a week. Additionally, if the employee fails to work 80 hours a week, for example, if they work 30 hours a week for employer A and 30 hours a week for employer B, they would then be violating both H-1Bs. So it's typically recommended to file a concurrent filing for part-time employment. I'd like to give two examples of how this would work in practical terms. So in the first example, we have an employee who is working for employer A for 40 hours a week and wishes to work for employer B for 20 hours a week. In those circumstances, employer B would need to file a concurrent H-1B filing. As soon as that petition is filed and received by USCIS, the employee would be able to start working for employer B. As long as there's no changes to the employment with employer A, then there would be no need for employer A to file any further petitions. However, in the second example, let's take the same set of facts, but in this scenario, after working for employer A 40 hours a week and employer B 20 hours a week, the employee decides that they no longer want to work that many hours, and the employee speaks to employer A and they agree to a reduction in hours. A reduction in hours would be considered a material change in employment, which means that employer A would then need to file what's called a H-1B amendment. We haven't discussed H-1B amendments, but whenever there is a material change in employment, for example, a reduction in hours, a reduction in pay, or a change in work location, a H-1B amendment would need to be filed. So just to conclude, it is possible to work for two employers at the same time, but the second employer would need to file a concurrent filing. If there's no changes to the original employment, then the original employer would not need to take any steps, but if those hours are reduced, then a H-1B amendment would be required. Again, I'd like to say thank you for watching this video. If you didn't check out the first video, an introduction to H-1Bs, please do so. Otherwise, please continue to check our website, patellegal.com, for further articles and videos. Thank you and have a good day.